Now, this week, the Portfolio Committee on Mineral Resources held its last public hearings on the Mineral and Petroleum Resources Development Amendment Bill. The bill seeks to amend and remove ambiguities that exist in the Mineral and Petroleum Resources Development Act of 2002. Joining us in our Cape Town studio for details is Henk Smith, attorney at the Legal Resources Centre, and Ibrahim Takolia, CEO of the SA Gas and Oil Association. Gentlemen, thank you so much for joining me. Henk, let me bring this first question to you. What are the main issues of ambiguity?
Masipo, we were saying no mining without community consent, if mining is to happen on communal land in the former homelands. So that was the main concern of the communities, two groupings of which had opportunity to make representations last week in Parliament, because the department never consulted with communities this year once the bill has been formulated. The bill covers a range of ambiguities. It attempts to clarify a number of issues, but on the very important issue of community participation in the decision, in negotiations about mining on their land, in this year, 2013, 100 years after the 1913 Land Act, unfortunately, the bill does not speak to this situation. The recent and historical experiences of communities in the former homelands has been that the state decided on their behalf what's good for them, and this in relation to Marikana experiences and the anniversary of the 1913 Land Act was not good enough according to the communities that had their voices heard last week in Parliament.
Ibrahim, would you share those sentiments for the South African Oil and Gas Association? What were your main contention points that you wanted to have thrashed out in the last public hearing?
Really, what we were looking at is the thrust of our presentation to the committee was really around opportunity and clarity. Opportunity really around the oil and gas industry and its potential to create jobs in South Africa, and also to really develop what I would call upstream and midstream industry within South Africa. And so that's the opportunity side. In terms of clarity, what the industry was really looking for is clarity around certain issues, particularly with respect to ownership, that is black economic empowerment. There was a free carry interest component, and then also the parameters to acquire a further interest. And then the other issues that we're really looking at was the transfer of licensing to the regions, and we mentioned that there might be some issues around if they transfer the licenses to the regions around capacity building, the alignment of cross-border fields, and then a single designated agency, which is something we support and which is in the current framework, but which they intend disbanding. And then also the prescribed periods in which to review applications, which we believe should be in line with global standards. And then so the thrust of our application was really around removing some of those, or at least dealing with some of those uncertainty issues, because oil and gas is really a multi-billion rand or multi-billion dollar industry, and the upfront investments and the risks involved are significant.
Ibrahim, of course, there has been that counter-argument to measuring South Africa alongside, or benchmarking South Africa alongside global standards, and the counter-argument calling for South Africa to be considered, or South Africa's mining sector to be considered a developing sector. How have you responded to that, and how have you taken that on in your presentation?
Yeah, essentially a number of the people who presented on the oil and gas industry were of the view, including us, that we should recognize that the mining industry is very mature and that the oil and gas industry is really in a different stage of development. And essentially what we believe is that it would be useful to look at legislation that treats the oil and gas industry at its stage of development, as opposed to treating the oil and gas industry in the same way that it treats the mining industry, which is at a very, very different stage of development, and also requires a different level of investment and a different level of expertise and technical knowledge, which South Africa has in abundance for the mining industry, but is really really only starting to take off in the oil and gas industry.
Hank, should the amendments that have been made, proposed for this bill go through as an act, what will the future of mining in South Africa look like from your perspective?
The mining industry in South Africa after 150 years require transformation. The bill does not bring that to rural communities. There are encouraging signs in the bill itself, if not in the bill itself, possibly in the revised mining charter, that there are encouraging aspects in the revised mining charter. In particular, the revised mining charter graduates from an approach of black economic empowerment, promotion of entrepreneurs, to a new stage of broad-based economic empowerment, socio-economic empowerment. And we're saying that when it comes to communities whose land is going to be mined in the former homelands, the equity stake of 26% should go exclusively to those communities. So the bill does not bring consent, free prior informed consent, which has become a standard, which is even appropriately adopted by certain of the banking groupings that lend money to the mining companies, has not adopted the best industry practice as promoted in other parts of the world. But there is, so there's much room for improvement.
From a legal perspective, Henk, again, what is the process that is about to unfold likely to look like? Do you have scope to contend some of the amendments that were proposed today, or does it seem as if the bill is well on its way to becoming law?
Parliament had a truncated period of consultation. It's not taking it to the mining districts and the host communities to comment on the bill. And the bill, if it goes through in its current format, it will give wide discretions to the minister, who may, if she so believes, set conditions to new mining rights. Regarding existing mining, the only possibility to promote community interests would be through the charter provisions for ownership and economic empowerment. So much is left to the discretion of the minister, which makes the mining companies uncertain, and this is something that we probably do not need at this stage in our industry.